Hello all. So today we are going to start our third session of our ongoing playlist, which is on various laws related to real estate. In today's session we are going to cover RERA Act, and under RERA Act we will talk about RERA Registration, Escrow Account, deemed RERA approval guidelines, revocation of RERA registration, duties and rights of promoters and allottees, penal provisions for promoters and allottees, offences by companies, and grievance mechanism under RERA Act. So this is the full syllabus as per IBBI exam, which carries 8 marks of theory as per existing syllabus, and as per revised syllabus the revised marks for this theory portion will be 7 marks with effect from 1st July 2022. So land acquisition part we have already covered in session number 1. This TP Act, Transfer of Property Act, we have already covered in session number 2. In today's session we are going to cover salient features of RERA. It's a full-fledged act, but we will cover key important bullet points of the act which are relevant for IBBI examination purpose. And in next and fourth session, last and fourth session, we are going to cover upon important aspects of rent control laws, right of way and section 52, and laws related to inheritance and succession. So let us understand what is the background of RERA Act. It is an act to establish the real estate regulatory authority for regulation and promotion of the real estate sector, and to ensure sale of plot, apartment or building. Please note down, this RERA is applicable on all three: plot, apartment and building. There is misconception in the market that RERA is not applicable on plots, but it is applicable on plots as well, as the case may be, or sale of real estate project in an efficient and transparent manner, and to protect interest of consumers in the real estate sector, and to establish an adjudicating mechanism for speedy dispute redressal, and also to establish the appellate tribunal to hear appeals from the decisions, directions or orders of the real estate regulatory authority and the adjudicating officer for matters connected therewith or incidental thereto. It is also called Real Estate Regulation and Development Act 2016. The RERA Act 2016 envisages establishment of RERAs in each state, and the Act empowers the buyers by bringing in more transparency through various measures. So this is the background, brief background. Please note down, it is applicable on plot, apartment, building. The Act is envisaged or incorporated for regulation and promotion of real estate, to protect interest of consumers, and to establish an adjudicating mechanism for speedy real estate sector real estate dispute redressal. So there are few important definitions which are covered into RERA Act, are explained into Act. Let us go through these important definitions. So first important definition is carpet area. It means the net usable area, floor area of an apartment, excluding the area covered by the external walls, areas under service shafts, exclusive balcony or veranda area, and exclusive open terrace area. But it includes the area covered by the internal partition walls of the apartment. So this definition of carpet area, please be clear about it. Estimated cost of project. It means the total cost involved in developing the real estate project, and includes the land cost, taxes, cess, development and other charges, etc., if any. What is the meaning of competent authority as defined in the Act? It means the local authority or any authority created or established under any law for the time being in force by the appropriate government, which exercises authority over land under its jurisdiction and has power to give permission for development of such immovable properties. Commencement certificate, it is issued by the competent authority to allow or permit the promoter to begin development works on an immovable property as per the sanction plan. It is also called building permit or construction permit. So commencement certificate, building permit or construction permit, all are these three same terminologies as per RERA Act. Completion certificate, it is also issued by competent authority and certifying that the real estate project has been developed according to the sanction plan. So whether the construction has been done as per the building plan or not, it is being certified by way of providing completion certificate. Sanction plan, layout and specification as approved by the competent authority under the local laws. Occupancy certificate, it is issued by the competent authority permitting occupation of any building as provided under local laws, which has provision for civic infrastructure such as water, sanitation, electricity, etc. EDW and IDW, external development works and internal development works. These are also two important terms which we should know. So EDW, external development work, includes roads and road system landscaping, water supply, sewerage, drainage system, electricity, water supply transformers, substations, solid waste management and disposal, or any other work which may have to be executed in the periphery of or outside a project for its benefit as may be provided under the local laws. And what is the internal development work? It means roads, footpath, water supply, sewer, drain, parks, tree planting, street light, provisions for community building and for treatment and disposal of sewage and sluggish water, solid waste management and disposal, water conservation, energy management, fire protection and fire safety requirement, social infrastructure such as educational, health and other public amenities, or any other work in a project for its benefit as per the sanctioned plan. So external are, as name suggests, is being executed outside the periphery of the project, and this is within the periphery of the project. Garage, it means a place within a project having a roof and walls on three sides for parking any vehicle, but doesn't include an unenclosed or uncovered parking space such as open parking area. So open parking area is not defined in RERA. If garage word is used in any sale agreement, so that is the definition. It should have a roof and three side wall. Local authority, it means the municipal corporation or municipality or panchayats or any other local body constituted under any law for the time being in force for providing municipal services or basic services as the case may be in respect of areas under its jurisdiction. Planning area, it means a planning area or a development area or a local planning area or a regional development plan area. So all these terminology are same by whatever name called or any other area specified as such by appropriate government or any competent authority, and includes any area designated by the appropriate government or the competent authority to be a planning area for future planned development under the law relating to town country planning for the time being in force and as revised from time to time. Now, who is a promoter as per RERA Act? A person who constructs or causes to be constructed an independent building or a building consisting of apartments or converts an existing building or a part thereof into an apartment. So these three terms are there. For the purpose of selling, selling is important, not for self-consumption. For the purpose of selling all or some of the apartment, either all the flats or some of the flats, to other person and includes his assignees. So this is the first definition of promoter. Second definition is a person who develops land into a project whether or not the person also constructs structures on any of the plots for the purpose of selling to the other persons, all or some of the plots in the said project, whether with or without structure thereon. So this is regarding plotting. And third one, any development authority or any other public body in respect of allottees of buildings or apartments, as the case may be, constructed by such authority or body on lands owned by them or placed at their disposal by government, or if not building or apartment, in case of plots, then plots owned by such authority or body or placed at their disposal by the government for the purpose of selling all or some of the apartments or plots. So basically selling should be included into this, only then a person will be called as promoter. If any construction is being done for self-consumption purpose, then as per RERA Act, the person who is constructing or causing construction of the building is not a promoter. Then who else can also be a promoter? An apex state level cooperative housing society, housing finance society, and a primary cooperative housing society which constructs apartments or buildings for its members or in respect of the allottees of such apartment or buildings. Any other person who acts himself as a builder, colonizer, contractor, developer, estate developer, or by any other name or claim to be acting as the holder of a power of attorney from the owner of the land on which building or apartment is constructed or plot is developed for sale, he is also a promoter. Such other person who constructs any building or apartment for sale to general public. So basically intent should be to sell the property, at least entire property should be sold or part of the property should be sold, only then a person will be called as promoter. In case where the person who constructs or converts a building into an apartment or develops a plot for sale, and the persons who sell apartments or plots are different persons. So in cases when the person who constructs or converts a building into apartment or develops a plot for sale, and the person who sells the apartment and plots are different persons. So one person is constructing, other person is selling. Both of them shall deem to be promoter and shall be jointly liable as such for the function and responsibilities as specified. Please note down this point because theory mark question can come out of this slide. That in case one contractor is constructing a building and other person is selling the houses, then as per RERA Act, both are tend to be classified as promoters. What does person include? As per RERA Act, it includes an individual, HUF, Hindu undivided family, a company, a firm under Indian Partnership Act 1932, or a limited liability partnership as per 2008, as per the case may be, a competent authority, an association of person or a body of individual, whether incorporated or not, a cooperative society registered under any law relating to the cooperative societies, any such other entity as the appropriate authority may be by notification specify on his behalf. So prior registration of real estate projects. So these are the guidelines. No promoter shall advertise. As per RERA Act, no promoter is allowed to advertise, market, book, sell or offer for sale or invite persons to purchase in any manner any plot, apartment or building, as the case may be, in any real estate project or part of it in any planning area. So important word is planning area, without registering the real estate project with the RERA authority established under the Act. So it is mandatory. So earlier builder used to do soft selling, cold selling, pre-launch. So those things are not permissible as per the RERA Act. If the authority thinks necessary in the interest of the allottees for projects which are developed beyond planning area but the requisite permission of the local authority, it may be by order direct the promoter of such to register with the authority, and provisions of the Act and rule shall be applicable on those projects outside planning area. So basically, many times we discuss that whether RERA is applicable on the project or not. So if it is falling within planning area, then it is applicable. and other guidelines of which we will see subsequently, with the plot size and number of units, dwelling units, to make any plot eligible. So first condition is the land should fall in planning area, and second and third condition we will discuss in subsequent slide, which is regarding land area and number of dwelling units. Exemption of registration of real estate. So when the area of land proposed to be developed doesn't exceed 500 square meters. So please note down this this figure. So land area doesn't exceed. So up to 500 square meter land area is exempt from RERA, and the number of apartment proposed to be developed doesn't exceed 8. So up to so if plot area is more than 500 or number of dwelling units are more than 8, either of two gets triggered, then RERA is applicable. 1 mark theory question can come out of it. If the appropriate government consider it necessary, it may reduce the threshold below 500 square meter or 8 apartments, as the case may be, inclusive of all phases for exemption from registration under this act. So it depends on the because RERA is a central act, and then state-wise RERA has been incorporated. Where the promoter has received completion certificate for a real estate project prior to commencement of this act, so then those projects are exempt. Completion certificate is mandatory to be obtained before incorporation of the RERA Act. For the purpose of revocation or repair or redevelopment which doesn't involve marketing, advertising, selling, or new allotment of any apartment, plot or building, as the case may be, under the real estate project. Escrow account. So there are certain terms condition for the escrow account as per RERA Act. What are these? 1 mark theory question can also come out of it. So as per RERA Act, escrow account has to be opened, and 70% of the amount realized for the real estate project from the allottees from time to time shall be deposited in a separate account to be maintained in scheduled bank to cover the cost of construction and land cost, and shall be used only for that purpose only. The promoter shall withdraw the amount from the separate account to cover the cost of project in proportion to percentage of completion of the project. So as completion will be done, so accordingly money will be taken out, and minimum 70% of that amount should be utilized for the project itself. The amounts from the separate account shall be withdrawn by the promoter after it is certified by an engineer, an architect, and a chartered accountant in practice that the withdrawal is in proportion of percentage of completion of the project. There is an ongoing monitoring by these three people. The promoter shall get his account audited within 6 months after the end of every financial year by a chartered accountant in practice, and shall produce a statement of account duly certified and signed by such chartered accountant, and it shall be verified during the audit that amounts collected for the particular project have been utilized for the project, and withdrawal have been in compliance with the proportion of the percentage of completion of the project. So basically, after 6 months of the closure of books, the books have to be certified by the CA, and CA has to certify that money has been withdrawn as per guidelines stipulated by RERA, and money has been utilized for the construction of the project. Deemed approval guidelines, these are also important. On receipt of the application with all prescribed documents, the authority shall, within a 30 days, grant registration and provide a registration number. So these are the obligation on RERA authority also. RERA has to give within 30 days, grant registration and provide a registration number, including a login ID and password to the applicant for accessing the website of authority, RERA authority, and to create his web page to fill therein the details of the proposed project. So there, through that web login page, within 30 days, the builder promoter has to punch in the detail of his project. Reject the application, or authority within 30 days, authority can reject the application for reasons to be recorded in writing. If such application doesn't conform to the provision of this act or the rules and regulation made therein. No application shall be rejected unless applicant has been given an opportunity of being heard in the matter. So if some option is given for represent his file to the builder, then file should not get rejected under representation during review stage. If RERA fails to grant registration or reject the application within 30 days time, the project is deemed to be approved. Authority within 7 days after 30 days shall provide registration number along with login ID and password. Then post 30 days it gets automatically approved. Revocation of RERA registration. The authority may, on receipt of a complaint or suo motu of its own in this behalf or on the recommendation of the competent authority, revoke the registration granted under section 5 after being satisfied that the promoter makes default in doing anything required by or under this act, the rule or the regulation made thereunder, the promoter violates any of the terms or condition of the approval given by competent authority, the promoter is involved in any kind of unfair practices or irregularities, the promoter indulges in any fraudulent practices, right? So if any of these events get triggered, then the RERA registration can be revoked by RERA authority. But please note that authority need to give minimum 30 days of time or notice period to promoter before revocation of RERA registration. Registration of broker is also mandatory as per RERA Act. Please note down. Functions and duties of promoters. So the promoter shall, upon receiving his login ID and password, create his web page on RERA website and enter all details of the proposed project for public viewing, including details of the registration granted by the authority, quarterly up-to-date list of number and type of apartments sold, as the case may be sold or booked, quarterly up-to-date list of number of garages booked, quarterly up-to-date list of approval taken and approvals which are pending subsequent to commencement certificate, quarterly up-to-date status of the project, and such other information and document as may be specified by the regulations made by the authority. So local authority, whatever is said, all information the promoter has to update and some punch first time and also need to update on a quarterly basis. The promoter at the time of booking and issue of allotment letter shall be responsible to make available to the allottees the following information, namely as per the RERA Act. So first, sanction plan, layout plan along with specifications approved by the competent authority by display at the site or such other place as may be specified by the regulations made by the authority. The stage-wise time schedule of completion of the project, including provisions of civic infrastructure like water, sanitation and electricity. So these basic information are required to be provided by a promoter to each and every allottee. The promoter shall be responsible to obtain the completion certificate or the occupancy certificate or both as applicable and to make it available to the allottees individually or to the association of allottees, maybe RWA as the case may be, and be responsible to obtain the lease certificate where the real estate project is developed on a leasehold land, specifying the period of lease and certifying that all dues and charges in regard to the leasehold land has been paid, and to make the lease certificate available to the association of allottee RWA, and be responsible for providing and maintaining the essential services on reasonable charges till taking over of the maintenance of the project by the RWA or association of the allottees. The promoter shall also be responsible for enabling the formation of an association or society or cooperative society as the case may be of the allottees or a federation of the same under the RERA Act as applicable. So it is also responsible for executing a registered conveyance deed of the apartment, plot, building as the case may be in favor of allottees along with the undivided proportionate title. So it is also important. So while executing the conveyance deed or sale deed, the builder, it is duty of the builder to give undivided proportionate land share to each allottee in the common area to the association of the allottee or to the competent authority as the case may be, and pay all outgoings until he transfers the physical possession of the real estate project to the allottees or the association of allottees as the case may be, which he has collected from the allottees for the payment of outgoings including land cost, ground rent, municipal or other local taxes, charges for water or electricity, maintenance charges including mortgage, loan, interest on mortgage or any other encumbrances etc. To be removed by the builder or promoter. Then the promoter shall also be shall, after he executes an agreement for sale for any apartment, plot or building as the case may be, not mortgage or create any charge on that apartment. Once the plot or building or flat or apartment has been sold by the promoter, he cannot create any subsequent charge on that property, right? And if any such mortgage or charge is made or created, then notwithstanding anything contained in any other law for the time being in force, it shall not affect the right and interest of the allottee who has taken or agreed to take such apartment, plot, building as the case may be. Transfer title. The promoter shall execute a registered conveyance deed in favor of the allottees along with the undivided proportionate title in the common areas to the association of the allottees or the competent authority as the case may be, and hand over and the other title documents pertaining thereto within specified period as per sanction plan as provided under the local laws. In the absence of any local law, conveyance deed in favor of the allottees or association or RW of the allottees or competent authority as the case may be under this section shall be carried out by the promoter within 3 months from the date of issuance of the occupancy certificate. Now these are the rights and duties of allottees also. The allottee shall be entitled to obtain the information relating to the sanction plan, layout plans along with the specification approved by competent authority and such other information as provided by in this act or the rules and regulations made thereunder or the agreement for sale signed by the promoter. So this is first right of the allottee. The allottee shall be entitled to know stage-wise time schedule of the completion of the project, including the provisions for water, sanitation, electricity and other amenities and services as agreed to the between the promoter and the allottee in accordance with the terms and conditions of the agreement for sale. The allottee shall be entitled to claim the possession of the apartment, plot or building as the case may be, and the association of the allottee shall be entitled to claim the possession of the common areas. The allottee shall be entitled to claim the refund of amount paid along with the interest at such rate as may be prescribed and compensation in the manner as provided under this act from the promoter if the promoter fails to comply or is unable to give possession of the apartment, plot or building in accordance with the terms of agreement for sale or due to discontinuance of his business as a developer on account of suspension or revocation of his RERA registration under the provision of the act, the rule or regulation made thereunder. Further, the allottee shall be entitled to have the necessary documents and plans, including that of common areas, after handing over the physical possession of the apartment or plot or building, as the case may be. Every allottee shall be responsible, this is the duty of the allottee, shall be responsible to make necessary payments in the manner and within the time as specified in the sale agreement, and shall pay at the proper time and place the share of registration charges, municipal taxes, water, electricity charges, maintenance charges, ground rent and other charges if any. The allottee shall be liable to pay interest at such a rate as may be prescribed for any delay in payment toward any amount or charges as mentioned thereabove. The obligations of the allottee for payment of above charges and the penal interest may be reduced when mutually agreed to between the promoter and the allottee. Every allottee of the apartment, plot or building as the case may be shall participate toward the formation of the association or society or cooperative society of the allottees or the federation of the same. So RWA is required to be formed, so allottees have to be cooperative in that way. Every allottee shall take physical possession of the apartment. This is another responsibility, duty of the allottee within period of 2 months of the occupancy certificate. Every allottee shall participate towards registration of the conveyance deed of the apartment, plot or building as the case may be. Now, who can file complaint with RERA? Any aggrieved person may file a complaint with the authority or the adjudicating officer as the case may be for any violation or contravention of the provisions of this act or the rules and regulations made thereunder against any promoter, allottee or real estate agent as the case may be. For the purpose of this subsection, person shall include the association of allottees or any voluntary consumer association registered under any law for the time being in force. Now these are the penal provisions for promoters. If prior registration of the project is not done or the builder fails to comply orders of appellate tribunal, following penal provisions for promoters are there. So imprisonment up to 3 years and fine up to 10% of the project cost. 1 mark theory question may come out of this slide or next slide. If promoter provides false information or contravenes with the provisions of the Act, except non-registration, which is covered in point number 1, he shall be liable to a penalty up to 5% of the estimated cost of the real estate project as determined by the authority. If promoter fails to comply with any order or direction issued by RERA, the promoter shall be liable to pay daily penalty which may accumulate up to 5% of the project cost. Now these are the penal provisions for allottees also. If any allottee fails to comply with or contravenes any of the orders, decisions or directions of the authority, he shall be liable to penalty for the period during which such default continues, which may cumulatively extend up to 5% of the plot, apartment, building cost, as the case may be, as determined by the authority. If any allottee who fails to comply with or contravenes any of the orders or direction of the appellate tribunal, which is next to the authority, as the case may be, he shall be punishable with imprisonment of a term up to 1 year or with fine for every day during such default continues, which may cumulatively extend up to 10% of the value of plot, apartment or building, as the case may be. Offences by companies. In case an offence is committed by a company, firm or body corporate, it is provided in the Act that the offence has been committed with the consent and connivance of or negligence of any director, manager, secretary or any officer of the company, firm, body corporate. Such director, manager, secretary or any officer shall be guilty of the offence. So 1 mark theory question may come out of this slide as well. Due diligence and transparency. RERA enables the buyers to take out entire information of the project, land title details, approval status, etc. from the single point RERA website. Buyers can verify past track record of the builder through RERA website. This enables goodbye to earlier wrong selling practices of soft launch, pre-launch, etc. adopted by the builders. Developers need to incorporate the project RERA registration number in all promotional activities. So due diligence and transparency has been increased after implementation of RERA. There are certain key changes which have been implemented after implementation of RERA. First key change is that builder cannot take more than 10% as booking amount, failing which imprisonment up to 3 years can be given to the builder. Equal penal ROI for both buyer and builder should be stipulated in the builder-buyer agreement. This is again another point highlighted by RERA. Rates basis carpet area can only be quoted. Super area basis concept rate has been gone. Guidelines for project completion, amendment and maintenance. The builder is bound to deliver its project within specified time frame. In case of delay, the buyer can cancel the booking and can claim the entire amount paid with the interest. However, if buyer decide to go ahead with the delayed project, the builder has to pay monthly penal interest until the property is ready for possession. So these are the penal provisions. In case of delay, minimum 70% of the money collected from the buyer should be routed through the project escrow account, which we discussed in the previous slides. This amount can be withdrawn for purchase of land or construction of building only after submission of architect engineer CA certificate. Promoters need to take insurance of land title and building both. To make any changes in layout plan, builder is required to take consent of 2/3 of buyer. Please note on this point. 1 mark 3 question may come. Builder is liable to attend any building defect like plumbing, crack, etc. appearing within 5 years. Such defects should be rectified by builder within 30 days or is liable to pay compensation. So 1 mark theory question may also come from this point also. Transfer and assignment of promoter majority share to third party can be done by written consent of 2/3 of allottees, except promoters, and by RERA approval of RERA. So 1 mark theory question may come out of this point, this point, this point. Any one question can come. Grievance mechanism. For violation and contravention of Act, the aggrieved person maybe builder, buyer or broker may file a complaint to RERA Appellate Tribunal. The matter to be resolved within 60 days from the complainant date. So appellate body is one step ahead of the RERA Act, RERA Code. No civil court shall have jurisdiction over matters empowered to be decided by the RERA under the Act. So no court shall grant injunction in pursuance of any power conferred by court under this Act. So that's all about the RERA Act, which are relevant for the IBBI examination evaluation purpose. So before I'm going to tell you what we are going to have in our fourth and last session of our ongoing playlist, I would request you to please subscribe to the channel and click on bell icon so that you will be notified immediately after the next session will be uploaded. So this is the content which we are going to cover in our fourth session, which is the last session of the ongoing playlist. We will cover rent control laws, right of way, section 52, and laws related to inheritance succession. Thank you.